Hello, I'm Georgina Kersham. Welcome to this first session in Rope Walk Chamber's new series of animal and equine webinars. I'm going to start things off today with an examination of claims arising out of dog bites and dog swipes or collisions. After this presentation, there'll be a short break in which you'll have the opportunity to ask any questions. If you'd like to start posting any questions as they occur to you, you'll see the text box on the right-hand side of the screen. Now, at Rope Walk Chambers, we previously provided blogs and live seminars on the more detailed provisions of the Animals Act and its associated case law. So I'm not going to take you through all of the statute again in abstract. In this session, I'm going to take you through the provisions with reference specifically to dog bites and dog swipes, so that we can see how the Animals Act and its relevant case law can be applied in practice. We'll look at claims under the Animals Act 1971 and in common law negligence. We'll consider some of the key cases in this area and some of the defences that arise. As a domesticated animal, dogs are categorised as non-dangerous under the Animals Act. So we're concerned with liability under Section 2.2 of the Act. This section imposes strict liability on the part of the dog's keeper, provided that the three criteria set out under Section 2.2 are satisfied. Unfortunately, this happens to be the part of the Act which causes the most head scratching amongst even the most senior levels of the judiciary. But I'm going to try and demystify at least some of it today in the context of dog injury claims. We're going to consider two of the classic scenarios that commonly arise in this area of personal injury law. Firstly, we'll consider a claim by a delivery worker who's been bitten by a guard dog and suffered a nasty bite to the back of his calf, as he's tried to run away perhaps from the dog as it's chasing him up the path. The second common scenario is that of an elderly lady who's been knocked over by a boisterous Labrador in the public park while she's walking her own little Yorkshire Terrier. Those are what I refer to as dog swipe or collision claims. So here we have Section 2.2 of the Act in full. You'll see immediately that it's a dense piece of statute. I'm going to take you through each stage in turn in the context of the two types of dog injury claims that we commonly come across. But before we look at those criteria in detail, just pause for a moment to note that there can be more than one keeper of a dog at the same time. So you may find claims involving both the owner of the dog and its handler at the time of the injury. It's not necessary for someone to be in possession or in direct control of the dog at the time of damage, as long as they have some responsibility for it as its keeper. So let's come now to the three provisions of Section 2.2. And the first is Section 2.2a, which is concerned with the likelihood of injury. We're not required to look at that on the balance of probabilities. In this statutory context, likelihood is perhaps a lower bar. It's been characterised in some of the case law as something reasonably to be expected or such as well might happen. And there are two routes to liability for a claimant under this part of Section 2.2. First is if the damage is of a kind which the animal was likely to cause unless restrained, or damage, if caused, was likely to be severe. Just to pause for a moment about those words unless restrained. In my experience, they don't usually play a significant part in any claim. They're designed, in my view, to rule out an argument that we might see, for example, in a dog bite case. Well, he wasn't likely to cause injury because he's always muzzled, or he's always on a lead in a dog swipe case. There's simply a provision to ensure that that argument is eliminated. Lord Justice Jackson previously, in relation to this section of the Act, has suggested that this will only eliminate a very small number of Animals Act claims. But since then, that was a suggestion that he made in 2012, but it seems to me that since then courts have been more careful to scrutinise the provisions under Section 2.2a and to ensure that the evidence meets one or both of the two limbs. So turning then to look at these two limbs under in the context of a dog bite case. First question we ask is whether the dog was likely to cause injury. In our delivery man case, was the dog likely to bite, essentially? And if there is evidence to suggest that the dog has a history of biting, then this criterion and the first limb of it is likely to be met. Typically, though, the keeper will be quick-witted enough to say immediately at the time of the incident, "Darling Trixie, she's never done anything like that before. This is totally out of character for her." Now, in those circumstances, it's likely to be more difficult for a claimant to establish a likelihood of injury under the first limb of section 2.2a. That's not to say one should take the keeper's word for it. I've seen at least one trial judge, if not more, raise a judicial eyebrow at the defendant's adamant declaration that their 7-year-old family pet had only just bitten the postman for the first time in their life, and it was completely out of the blue. So as a claimant representative in such a case, you might want to make inquiries of other delivery workers, if the postman had colleagues, or if it was another delivery company, if there are others who deliver regularly to the property. You may consider talking to neighbours to see whether anyone is likely to be of assistance in giving evidence. On the other hand, as a defendant rep, you might want to ask some careful questions of your insured to establish whether the dog really has never previously shown any signs of aggression at all, whether it's growled or bared its teeth or chased a delivery worker previously. No matter which side you're acting on, though, you will need to take a very careful look at the veterinary records to see whether there'd been any previous complaints of aggression or biting on the part of the dog, or perhaps whether the vet insists on the dog being muzzled or sedated for any examination. Most commonly, though, section 2.2a is usually satisfied under the second limb, whether the dog was, if the dog was likely to cause injury, whether such injury was likely to be severe. Now, most judges are prepared to accept that a dog bite is likely to cause severe injury. Certainly with a larger dog, this is likely to be accepted without much of an argument. In Curtis and Betts, the Court of Appeal held that the defendant's bull mastiff belonged to a breed that was likely to cause severe damage if it did bite somebody. But I would argue that even with a relatively minor surface bite, it seems that injury is likely to be severe, or such as might well happen or reasonably to be expected. There's often a risk of infection, which may require treatment, and permanent scarring is a typical feature of any dog bite claim. Let's look at the same questions now in the context of our elderly lady who's been knocked down in the park by a dog. The first question we'll ask again is was the dog likely to cause injury? In the context of a dog collision, it's my experience that this test is much harder to establish. Unless you have a remarkably boisterous dog or a clumsy dog, many dog swipe cases are a freak accident with no prior history of any kind of collision or similar behaviour. So we look at the second limb of the test. If the dog did cause injury, was such injury likely to be severe? Generally speaking, if a dog does buffet into someone, it will not necessarily cause severe injury. It may be that our elderly lady in this example was particularly unlucky because she was unsteady on her feet already, or she had osteoarthritis. But that eggshell skull principle does not assist the court in considering objectively whether injury caused by the dog was likely to be severe. In Turnbull and Warrener, an equine case, the court warned against assuming that injury was likely to be severe simply because the claimant did in fact suffer severe injury. Welsh and Brady was a Scottish Animals Act case involving a black Labrador that caused injury to another dog walker when it ran into her. In that case, the expert evidence did not establish either a likelihood of injury or of injury being severe, and therefore the claim under the Animals Act failed. It seems to me that generally it will be very difficult for a claimant to prove either of these two limbs in a dog collision case. It's much more difficult than when we consider the likelihood of injury or of it being severe in a dog bite case. So let's turn now to the second limb of section 2.2. Section 2.2b is concerned with characteristics. The leading authority on this subsection is the House of Lords decision of Merverhady and Henley. That involves some horses that had escaped from a relatively secure enclosed paddock, but onto a busy road where they caused injury. The House of Lords sought to clarify the interpretation of section 2.2b, and they considered that it would offer two alternative routes to liability. In the context of a dog injury, it requires us to consider, firstly, what were the characteristics that gave rise to a likelihood of injury or of injury being severe? And then once we've identified those characteristics, we then consider, firstly, is that characteristic abnormal in the species of dog? Or alternatively, was it normal in the species, but only at particular times or in particular circumstances? And the damage was caused in those particular times or circumstances. Let's look at the first part of that test, the abnormal behaviour or abnormal characteristic. In my experience, most experts will say that neither biting nor collision is a common or normal behaviour in any breed of dog. Even breeds with a bad reputation for aggression will not normally bite without some sort of provocation or in particular circumstances. So generally speaking then, this first limb will only really be made out if the dog has a history of biting or perhaps more rarely colliding with people that is abnormal for the species of dog. One example where the court has been satisfied that the dog had an abnormal propensity to bite can be found in Kite and Nap. In that case, the claimant was bitten by a dog that was known to attack people carrying bags. This was found to be a characteristic that was not normally found in animals of the same species. On the other hand, when we consider dog swipe cases, I'm sure someone will let me know if there is a relevant decision, but I've certainly not come across a dog swipe case where the dog was found to have had an abnormal propensity to crash into people. So most commonly then, we're concerned with section 2.2b, the second limb of the test, and that is where the claimant must show that the characteristic which caused the likelihood of injury, which caused the dog to bite in the dog bite case or to collide with someone, was a normal characteristic, but only at particular times or in particular circumstances. Mulcahy and Henley considered what might constitute normal or particular times or particular circumstances. And in the context of a dog bite case, it was given as an example that a bitch with a litter of pups or a guard dog defending its territory might be perfectly placid in the vast majority of circumstances, but that it would be still considered normal for that dog to bite in those particular circumstances of defending her pups or defending its territory. And that would be the type of example where the criterion under the second limb of section 2.2b would be made out. A brief word, sort of practitioner's tip on this provision. It's often said that expert canine behaviour evidence is required to satisfy section 2.2b. And certainly where the circumstances of the injury are not straightforward, I would err on the side of caution and would obtain expert canine behaviour evidence as to what caused the dog to bite and whether that behaviour is normal or abnormal in those particular circumstances. In many dog bite cases, though, it will be accepted by the defendant that dogs can react aggressively in defence of their territory or when being protective towards their owner. So this criterion might be effectively dealt with cost efficiently through Part 18 questions of the defendant or through a notice to admit facts. Turning to our specific example of the postie who's been bitten by the dog whilst he's going about his rounds, it's not usually difficult to establish section 2.2b on the basis that the dog was biting in defence of its territory. That would constitute a normal characteristic in those particular circumstances or at those particular times. This same question is more problematic in a dog collision case, however. Firstly, it has to be shown that the collision is due to a characteristic. And in Turnbull and Warrener, Lord Justice Stanley Burton warned against being too quick to attribute a characteristic where there's simply a one-off action. Similarly, in Clark and Bolt, it wasn't accepted that moving otherwise than as directed amounted to a characteristic in a horse. And applying those same principles, there would probably need to be some further behaviour in order for the court to be satisfied that a dog collision, a one-off erratic incident, was due to a characteristic in the dog. And that was the difficulty for the claimant in the case of Hunt and Wallace. This was a claim arising out of a dog collision involving a border collie. And it was found that the severity of the injury, was likely to be severe, but that was due to the characteristics of speed and size in the case of a border collie. But when we consider section 2.2b, those characteristics of size and speed are not abnormal characteristics for the species, nor are they normal only at particular times or in particular circumstances. Those characteristics are always present in a fully grown border collie. And so the claimant therefore failed to establish that causal link that is required between the characteristics that meet the criteria under section 2.2b and the likelihood of injury or of it being severe. The court went on to consider the hypothetical scenario if the claimant had put her case in a different way and said that running into people was a characteristic that was normal at the particular times and circumstances which existed, namely that the dog was excited because there were some visitors to the farm. And in that alternative scenario, the court found that running into people wouldn't necessarily amount to a characteristic in and of itself, And those circumstances of being excited of new visitors wouldn't necessarily amount to particular circumstances or particular times in which that behaviour is normal. The court was satisfied that border collies are likely to be boisterous or fast at all times, and not just in those particular times. We turn then to section 22C of the Act, and that requires the claimant to show that the defendant had knowledge of the characteristics which gave rise to a likelihood of injury. Now, this must be actual knowledge. It's not sufficient to show constructive knowledge, but it is enough to show that general knowledge of the characteristics that are normal in that particular species amounts to knowledge for the purposes of this section. So, for example, if the defendant accepts that dogs can be aggressive and it's normal for dogs to be aggressive in defence of their territory, that would amount to knowledge of the characteristic under section 22B. Where the claimant is relying on a characteristic that is normal only at particular times or in particular circumstances, the claimant must also show that the defendant knew of those particular times or particular circumstances that prevailed at the time of the incident, and that it is normal for that characteristic to be exhibited in those times and circumstances. And that principle arises from the case of Ford and Seymour Williams, in which our own Georgina Crawford at Chambers appeared for the successful defendant. So applying that principle in the dog bite context, a keeper might know as a general principle that it is normal for a dog to bite in defence of its territory. But that keeper might not know that his dog had a latent medical condition which would cause it suddenly to bite or to start behaving aggressively out of the blue. Now, if the bite occurs as a result of the normal and predictable circumstances of defending its territory, then the defendant would have the requisite knowledge. But if the bite occurs as a result of the unknown condition that the defendant couldn't reasonably have known about, then the claimant will not be able to establish knowledge under section 22C. Normally, as a matter of general principle, in a dog bite case where a dog is behaving predictably in the particular circumstances that prevail, or where it has a known history of biting, this section is likely to be made out if the other sections have already been established. On the other hand, in a dog swipe case, it will generally be more difficult to prove unless the dog had a known history of colliding with people or being particularly clumsy, that the defendant was aware of the characteristic in question. We consider now some of the statutory defences that arise under the Animals Act. And there are three defences under section 5 that provide a defence to a claim brought under section 2.2. The first of those two defences are there on the screen, and they relate to injury caused entirely by the claimant's own fault, section 5.1, or injury for which the claimant has voluntarily accepted the risk, section 5.2. In relation to voluntary acceptance of risk, this is generally a lower bar than the common law defence of Valenti. The first instance decision of Presky and Sutcliffe that you see there on screen is an example of how both of these two defences have been applied to a dog bite claim. In that case, the claimant was bitten by the defendant's boxer dog. The defendant worked at a public house and he had his dog there at his place of work. And it's the claimant's case that the dog was trying to escape from the pub and went through the claimant's legs. And on seeing that the door was open and that the dog might escape, the claimant bent down instinctively to grab hold of the dog, at which point the dog turned its head and bit the claimant to the face. And in that case, it was found that section 2.2 was made out, but that the defendant did have the benefit of those two statutory defences under section 5.1 and section 5.2. Because by restraining the dog as he did, the claimant had voluntarily accepted the risk that it might feel threatened, and he therefore fully exposed himself to the risk that the dog would bite in those circumstances. It was further found that the claimant's actions in trying to restrain the dog were the sole cause of his accident, and therefore his claim was dismissed under the statutory defences. See the final bullet point on the slide there. It's important to note that voluntary acceptance of risk does not apply to employees of the keeper of the dog acting in the course of their employment. So, for example, where you might have dog walkers employed by a dog's trust, they won't be found to have accepted the risk of being bitten or being knocked over by a dog if they're out walking it. Considering then our two scenarios, thinking of our postman coming to deliver the mail, if he's bitten in the ordinary course of his delivering the mail, it's difficult to see how he might have accepted the risk of injury or caused the injury himself through his own fault. But if, for example, the dog is in a garden fenced off from the path up to the front of the property, minding its own business, chewing a bone perhaps, if the claimant were found to have leaned over the garden wall in order to engage with the dog, he could well then be found to have caused the injury entirely by his own intervention, or to have accepted the risk of injury voluntarily. It seems to me in those types of circumstances, it's more likely that Section 5.1 or 5.2 will be made out, and the claim would fail on the statutory defences. In dog swipe cases, it's often argued that the claimant was encouraging her own dog to play with the defendant's dog, which ultimately caused the collision, or in any event that by having her own dog off the lead, she's accepted the risk of injury. And as can be seen from the decision of Goldsmith and Patchcock there, it's not necessary to show that the claimant foresaw the precise degree of energy that the animal might engage in its behaviour. It's sufficient for the claimant to have foreseen that there was any risk of being knocked over by a dog, or even a collision with a dog, not necessarily for her to have foreseen the speed or the force at which a dog might collide with her. Section 5.3 of the Act is of particular relevance to dog injury cases. This provides that there's no liability under Section 2.2 where the claimant is a trespasser, provided that the dog is not being kept as a guard dog unreasonably. Now, considering our two scenarios that we're looking at today, it seems unlikely that this defence will arise. But to give you another example of a case in which I've been involved, I represented a farmer whose Rottweiler had bitten a walker who had accidentally strayed off the footpath and through the farmyard. Now, the defendant in his evidence very plainly told the judge that he kept the dog as a guard dog because she was a vicious bitch who would keep trespassers away. And it was held, nevertheless, that in that case, the claimant was a trespasser, no matter how innocently he had veered off the public footpath and was not entitled to be on the farmyard where he found himself. And further, the court found that it was reasonable for the defendant to keep the dog as a guard dog in circumstances where there was evidence that there had been numerous break-ins at the farm and thefts of farm machinery. And further, there was evidence that the defendant had placed very large signs directing people away from the farmyard and onto the public footpath. And for all of those reasons, the claim was dismissed on the grounds that Section 5.3 was made out. Let's now turn to the liability at common law for dog injuries. Now, both dog bite and dog swipe claims, the starting point is the reasonable foreseeability of injury. And this was considered in the dog swipe claim of Whippy and Jones. This was a claim involving a 12-stone Great Dane known as Hector. He'd knocked over a runner, the claimant, in a public path. Now, Hector had a propensity to approach strangers and bark at them, but he didn't have any history of aggression and there wasn't any history of collision. And in those circumstances, the defendant was held to have acted reasonably in unleashing the dog in the absence of any previous history. And Lord Justice Aikins considered the duty of a dog owner in these circumstances in the common law. The court must be satisfied that a reasonable person in the position of the defendant would contemplate that injury is likely to follow from his acts or omissions. Nor is the remote possibility of injury enough. There must be sufficient probability of injury to lead a person in the position of the defendant to anticipate it. Now, considering our dog bite claim, in my view, negligence very rarely adds anything to a claim under the Animals Act. In our postman scenario, common law is unlikely to assist the claimant unless there were evidence that the dog had a known history of aggression, such that there was a reasonably foreseeable risk of harm against which the defendant was required to take action. But that very rarely arises. As we've already seen in so many dog bite cases, the defendant will say immediately that the dog has never bitten before and there was no reasonably foreseeable risk of injury. I can think of one case in which I've been involved where negligence did play a greater part, and that was primarily because there was likely to be a defence made out under Section 5 of the Animals Act. I represented the defendant who'd placed large signs around the front of her property, warning passers-by or would-be trespassers that her husky dog was vicious and liable to bite. The claimant was walking along the footpath next to the defendant's house, and she saw the said husky dog enjoying a bone in the front yard of the defendant's property. The claimant decided to lean over to stroke the dog, and she was bitten. The claim under the Animals Act failed because the statutory defences, Section 5.1 and 5.2, were made out. The claimant had brought the injury upon herself by interfering with the dog, enjoying a bone, minding her own business, and had accepted the risk of injury given that there were signs and a locked gate on the property. The negligence claim was more closely fought, and it seemed that the judge was struggling with the question as to whether the defendant had taken reasonable steps to protect any passers-by from this reasonably foreseeable risk of injury. Ultimately, the judge found that there was no negligence in that case and that the defendant had done enough by placing the signs there and by keeping the gate locked. In dog swipe cases, there is a long line of authorities which suggests that the courts are generally reluctant to find common law liability on the part of dog owners whose dogs cause collision where there's known history of injury or reasonably foreseeable risk of the same. We've already looked at Whippy and Jones. One case that comes up a lot is that of Menzies and Doggy daycare. We frequently see it relied upon by insurers in defence of a dog collision claim. My only word of warning in relation to that case is that it is a first instance decision and it was an extemporary judgment. So there's no real authority as such when it comes to that decision, but it was useful insofar as it was a good analysis of the relevant case law, considering the facts of that case, another dog collision case. Looking at the more authoritative provisions that were considered in Menzies, the case of Hunt and Wallace, the border collie who got too excited and collided with a visitor. In that case, it was held that the dog owner did not fall below the standard of conduct expected of them in allowing the dogs to roam freely in the vicinity of the claimant. And Mr. Justice Pill said, "I do not find that the defendant was negligent on the evidence. The risk of collision, taking the risks of deliberate and accidental contact cumulatively, was extremely small." Mr. Justice Pill also had regard to the fact that there was no evidence of any previous or subsequent incident, and so the defendant did not fall below the standard of conduct that was expected of him. In Addison Campbell, a Court of Appeal considered a dog walker's liability for a dog that had collided with the claimant. And it was held there that the essential difficulty with the claimant's case was that there was no basis for a finding that the defendant should or could have foreseen that if he hadn't taken control of the dog, there was a risk of injury to anyone. And so no negligence was made out there. Cook and Jackson is a key Court of Appeal decision because it seems to buck the trend against the other dog swipe cases. But it's important to note that it was decided on the specific facts of that case. It starts well for the claimant in the judgment of Lord Justice Buxton because it was made clear that there was a duty on dog owners to exert control over their dog in a public space. That's a broad assumption that dog owners have a general responsibility to control their animals. And Lord Justice Buxton went on to consider the standard of care to be imposed on the dog owner and found that what is reasonable control depends on the circumstances of the particular case. Now, in the case of Cook and Jackson, the key factors in that case were that the dog was on a footpath that was dedicated to pedestrians. And so it was held that the defendant had a particular duty to be alert to the interests and safety of the pedestrians using the footpath. Secondly, it was found that in order to discharge that duty, the defendant needs to be in a position where he could see what the dog was doing and therefore prevent it from endangering the users of the footpath. That was a matter of common sense, said the judge. But in Cook, the dog owner was found liable on appeal for the damage caused by the dog because she was a user of she was exercising her dog whilst on her bike. And so she and her bicycle were some way ahead of the dog, and she was not then exercising sufficient control over the dog. Lord Justice Buxton distinguished that decision or that case from other dog collision claims by saying that this case is therefore quite different from the example given in argument of an owner throwing a stick for a dog to retrieve on the grassy part of a park, which is not a confined space and which is not dedicated to pedestrians in the way that the path is. So if we consider our scenario with the elderly lady, it seems that if she were in an open area of grassland, it would be very difficult to distinguish her case from that line of authority in which negligence has not been made out against the defendant. But perhaps if there was something more, if she were in a more enclosed space or on a particular dedicated footpath, then there may be more sufficient grounds for distinguishing that case from the circumstances, the decisions that have gone before. As we saw in Cook, the onus is on the defendant to take particular care for pedestrians. So, for example, if the defendant were throwing a ball or a stick back and forth across a footpath or along it, then that defendant would need to take care to ensure that it was not throwing a ball in such a way as to endanger the pedestrians along the path. So let's turn now in summary and to look at the questions that you might consider when dealing with dog bite or dog swipe claims. Turning firstly to dog bite claims, it seems that generally it's not likely to be difficult to establish Section 2.2a of the Animals Act. Dogs are likely to cause severe damage if they do in fact cause damage by biting. The characteristics which give rise to a biting injury are likely to be something along the lines of aggression or a propensity to bite. Times and circumstances in which the bite occurs can often be identified as the dog feeling nervous or defensive or territorial over their food or property, protective of their owner, or indeed in pain. And it's common for the court to find that the defendant must have known of those characteristics as a general principle, that dogs would behave in that way in those circumstances. So it seems that the absence of a previous biting incident is not necessarily fatal to a claim under the Animals Act if the dog bit in predictable circumstances. But one must not forget the statutory defences under the Animals Act. It seems as a general trend that dog bite claims are more likely to fill the criteria under Section 2.2 of the Act, and perhaps even where a negligence claim will fail for want of reasonable foreseeability. Negligence might be of assistance, though, where perhaps a statutory defence is made out under the Act, but not such as to give rise to a common law defence. By contrast, if we consider dog swipe claims, in my view, generally speaking, dog swipe claims are more difficult to establish under the Animals Act. And we've seen in the case law that courts considering common law claims have generally shown some reluctance to curtail the freedom of dog walkers exercising their dogs off lead in a public space. It follows, therefore, that caution is required when advising claimants on the merits of any claim arising out of a dog collision. It's difficult when we look at the criteria on the Animals Act to show that the dog was likely to cause injury if this was indeed a one-off collision case, or that injury was likely to be severe, disregarding any additional factors that might be pertinent to the claimant's position. We've seen that it may be difficult to establish that the collision itself amounts to a characteristic, or that the prevailing circumstances or times were such as to render that behaviour normal for the species of dog. Despite the difficulties, however, it seems to me that it's not necessarily the case that every dog swipe claim will fail. My personal view is that courts have been rather lenient in some cases at least, although not all. It's recognised by the Court of Appeal, as we saw in Cook, that dog walkers do have a duty to keep dogs under reasonable control, and where they do fail to do so, such as to present a reasonably foreseeable risk of harm to pedestrians in the area, then negligence should be made out. So that concludes my part of the programme. We're going to take a short break now, and after that I'll return to answer any questions that you may have posted on the screen there. Thank you.